Hi, welcome everyone. Rhythm, will you start or should I start? You will start?
It started already, Rashmi. Please go ahead.
Okay. So welcome everyone. Thank you so much for joining in today for another of this AIMA sessions that we've got for our YLC leaders. Um, so today we have Gopi Jatin Trivedi with us. She's a senior partner and the head of patent division at YJ Trivedi and Company. Brings about 2 decades of expertise in IP law, intellectual property law. And that's what the session is also about today. And a practice spans patent drafting, prosecution, opposition proceedings, advisory, licensing, valuation, etc., etc. She's got a computer engineering background, so she's also an engineer along with being a lawyer. Is a registered patent agent and a certified patent valuation analyst. I didn't even know that these kind of, what you say, deeper kind of, certifications are there. So she is one of those and one of the very few people in the country, and she's one of the leading ones. Beyond patent law, she plays a key role in the firm's IP valuation and management team as well. She's actively involved with leading international IP organizations, participating in global conferences and serving in communities. She holds key positions. She's based out of Ahmedabad, and she holds key positions within the Ahmedabad Management Association and the International Trademark Association and the Gujarat Chamber of Commerce and Industry. Her contributions have been recognized with several accolades, and most notably in 2018, when YJ Trivedi and Company, which is our firm, achieved a world record for filing the highest number of patents in a single day. So, welcome, Gopi.
Thank you, Rashmi.
Thank you so much for being here.
Such a warm introduction. Thank you, Rhythm, for coordinating, and AIMA for this opportunity.
No. So we are very excited to have you here. So I wanted to go from your profile, which says that in 2018, you all filed the maximum number of patents in a single day, which was about 18. Can you tell us a little about the same?
Okay, so one of our clients, namely SAL Institute of Technology, based in Ahmedabad, wanted us to handle this project of filing 162 patents in a single day.
Wow.
And then we actually reverse engineered it. We prepared the drafts for a few months. We got them all ready, got them all signed. The official fees were collected. And on a very single day, we filed it. We filed for them because they wanted to do the world record. But the byproduct was really amazing. We also got the world record as an attorney to file those highest number of patents. So that's what it was.
So this is an unbroken record. It's a Guinness World Record?
Yes. So far it is unbroken.
Awesome.
I wish any of our participants want to break it. We would be more than happy.
Yeah, but we need to know, because I was doing some reading on IPR rights, and of course, patent is one part of it, right?
Absolutely.
There are lots of myths and confusion, and it's very, very vast. So I just want to ask you some quick questions, and because I'm a little confused. I think it'll help us understand a little more, and also give a context to the audience here.
Yes, please.
So my first question was, I was thinking about domain name, because that's what all of us have been. We buy a domain, etc. So if I have a domain name, I have a brand name protected automatically. Is it a myth or a reality?
It's a myth. It's absolutely a myth. Those are two different jurisdictions.
Okay, didn't know that. And how many years does a trademark protection last in India?
So it lasts for 10 years, and it can be renewed for next 10 years, and then eventually it can become eternal.
Okay, so but every year, every 10
Every
years?
10 years.
Okay, that also didn't know, because I thought I had very nicely trademarked my logo of my company logo, and I thought I'm done for life. Can a specific color be also legally protected for a brand?
Absolutely, yes. There are some beautiful examples. Let's say Cadbury has golden and purple. The Colgate toothpaste has red and white. So there are very classic examples and many others.
Wow. Okay, never thought about that. What protects the recipe of a Coca-Cola? Patent or a trade secret?
It's a trade secret. It's a trade secret. Absolutely.
So that's a combination. The recipe is a trade secret.
Trade secret.
And that also can get filed. That also you can cover.
That's an intellectual property which is claimed by keeping it secret,
Oh,
not telling to any authority, but by keeping it secret, it becomes a trade secret.
wow. So any product which also has a very unique design, does it also fall under IP rights?
Yeah, it falls under specific act called Design Act.
Wow. Okay. So if I am an employee and if I create some work, so who owns the work? Is it me?
It
If
is
I
the
have work?
employer who owns the work. If
Okay.
it is done within the scope of the employer's work description and within the premises or by the instructions of the employer.
Okay. And can a business method be patented in India?
No.
Okay. And can ideas alone be protected by copyright?
No ideas can be patented or copyrighted or trademarked. They have to be transpired to something feasible.
My God, there's just too much of information that needs to be answered.
No, it isn't. It isn't. We'll try to decode it.
Okay, so let's get into the details. So what exactly is intellectual property rights and why is it important in today's context?
So intellectual property rights are the rights which come from a human's intellect or mind. So any idea which eventually be converted into any invention or any brand name or any unique design or any textual expression, all these can be protected. Now, for what 4 different examples I have just given, there is a separate law for each one of them. For example, if I am working on a problem-solving methodology, I'm innovating something and trying to solve a long-standing problem, that solution would be protected under Patents Act, which is one of the intellectual property right. That is a separate one. Second number, if I am, putting on some brand on my product, then it becomes, or it can be protected under Trademark Act. Thirdly, if I have a unique design compared to my competitor or existing products, that can be protected very well under Design Act. And if I have expressed my thoughts by the means of any painting or poem, maybe textbook, website, and a few others, musical depiction, even the movies, etc., can be protected under copyright. These are main 4 pillars of intellectual property rights. Extending the same, the fifth one is geographical indication, which is from a particular place. If there is a very specific product, then it is protected under geographical indication, just like Darjeeling tea, Patan Patola, or other handloom items. Then, as Rashmi just asked about the recipe of Coca-Cola. So that is a trade secret. If you do not want to publish or let anybody know what exactly your key ingredients or recipe is, you kindly keep it secret. That falls under trade secret. And here there is no submission. In fact, you have to keep it secret. Right? And last but not the least, there is a Semiconductor Act also. So if you have a unique semiconductor layout, that can also be protected under Semiconductor Layout Design Act. So these are different intellectual property, which can be within one object or which can be over other different objects.
Wow. So we have trademark, patent, design, copyright, GI, trade secrets, semiconductors. So do you think it'll keep on increasing as the world gets into newer?
So in 2025, I would say it may increase because Semiconductor Act is quite the freshest one. It is 2001 Act.
Okay.
So it can,
Okay. No, great. So as I said, and I did say that, it is very vast and it is a little confusing because I don't know. I always thought patent was equivalent to a copyright, and copyright was equivalent to a trademark.
Okay.
So, that is what I think layman, we get a little, sort of confused about it. So, you talked about the main categories of the IPR that people should be aware of, and thank you so much for that. So, would you be able to give us some examples of using everyday objects? If you could, sort of.
I think on my desk right now there are several objects. I can pick up one of them. Even I'm sure the participants would have one of them on their desk. I would like to show you one. Let's say this is a mouse. Okay. So what we can see here is the logi, which is a trademark. Now this trademark has there are several elements in this trademark. Let's say it is written in a particular font, in a particular way, in a particular color. So all these can go under trademark. That's one thing. Now, secondly, there is a very convenient design which matches with the hand of a human. So that's an ergonomic design that shall go under the Design Act if it is unique. If it is unique. Even this color combination, if this is unique to this particular company, that can also go under trademark. Now, when I move this cursor, when I move this roller, my cursor changes on the screen. That means this device communicates with my CPU. Now, that is nothing else but the patent, because you are doing something innovative. You are connecting a human movement, hand movement, with the movement of the cursor or movement of the computer at the end. So that is very innovative. Now that process or that way of doing, no matter what kind of mouse it may be, it can do that. Right? So that's a scientific approach. That is an inventive approach. That is a problem-solving approach. So that goes under patent. And whatever manual comes with this particular product, or whatever details are shown, or whatever pamphlets or email circulation are created for this particular product by that company, would be very well protected under copyright. So a very product, such several products, I'm sure my participants would agree that this product has several such elements. Even not moving so far, our everyday product like pan has all these elements. So that is it.
So this is such an eye opener, the everyday products that we use in our hand and we take so much for granted has gone through trademark, copyright, trade secret, design, etc. And so you're saying that each of this mouse, etc., they might have got patented, whoever must have invented it.
For the first time. For the first time.
Yeah.
And then you can have incremental patents also.
Okay.
Right? So once invented, it doesn't mean that category really gets saturated.
So if you're enhancing that, then that
yes, absolutely. Because there are more than 95% of patents world over are incremental in nature.
Wow.
And rest are breakthrough.
So sometimes I think we all talk about breakthroughs, and sometimes with this farmer, and I think it's all movies, etc., where we're talking about somebody's building a new product or a new drug and everybody's fighting for it. So that is, which is very, very, the new one where, everybody's trying to, for example, the COVID vaccine, which happened. And I know there was this entire war which were between Pfizer and some other big, and I know, keep looking at a couple of these mobile phones. I think Apple and Samsung's, etc. They're always in the news saying, who's trying to, take away my design and the look of it, and who invented the new one. So could you give us some example of some real big, some cases that you can talk about, which it'll help us understand a little more better.
Okay, so I perceive it this wise. So though these companies are big, one fine day they were very small. Once upon a time, I would say.
Yeah.
Right? They just started, like you and me or every one of us. But when they started building their enterprise, those who are successful, they have realized the importance of intellectual property rights at quite an early stage. And every newness in the product have been identified and filed for any of the relevant intellectual property rights. And eventually they built a portfolio. And those portfolio gave them the market position, even market entry barriers. And that's how they could enjoy the monopolistic rights. So it's absolutely strategic. So IPR many times, it's felt as a cost, but it's actually you're building up the assets. Because the valuation is also done over intellectual property rights rather than the physical properties. The physical properties importance has reduced to even less than 0.0101 when valuation is being calculated. Rest is majorly the intellectual property rights, then your market expansion, your customer base, and know-hows.
No, no, absolutely. I think you're very right that, for example, it positions you, and of course, your brand also keeps building. So this is
So for example, I just need to finish. Let's say if we take example, very fresh example of Ola Electric, which is quite a new entity in this world of electric vehicles. They started with 1, 2, 3 patent filing, and right now, in last 3 years, they filed some 200 plus patents. So they have a current portfolio of 2733 patents.
Wow.
And you can imagine now whoever wants to enter into this domain would have a tough fight.
They'll have a fight with them. So isn't this most of the big companies would be doing that only, right? Starting from Elon Musk saying, okay.
Yeah, the big companies,
already.
absolutely. Big companies do that, or if you want to be big, do this.
Ah, okay. So it also, I think, I'm a co-founder in a edtech firm. I think for me, the first thing was around my brand name, which I was trying to look for. And I went to GoDaddy and I picked up a domain name. It was just a domain name and it was taken. And then when I looked at, saying, okay, can you give me the domain? That person asked me some, 75 lakhs or 80 lakhs or something.
Oh my God.
That's also a business, right? So I think people, I think people have made a business out of it. Okay, there's some interesting question from Dr. Ramesh Raina, which is around Coca-Cola. He's saying, as you said, the Coca-Cola keeps trade secret while filing trademark. Is it mandatory for them to reveal the ingredients and then and the process of manufacturing to FSSAI?
So that's a different domain, and they do that. They have to do that. To my personal knowledge, now this is beyond my, domain's expertise. But personally, I feel they have to file that. They have to submit, but that is kept in a very particular manner. So it is kind of disguised, not an exact information.
Yeah, because if FSAI, they'll have to see what are the health risks or whatever they have to, sort of tell them that these are the ingredients at least.
Absolutely. But this is beyond intellectual property rights.
Correct. Okay. I hope, Dr. Ramesh, your question is answered. Okay, so that was on IPR, and I think Gopi, it was really, really nice. People are also saying that you've explained it very, very simply, and thank you so much for that. So, so let me get on to some question around trademark, which we just had a question around trade secret. For a business just starting out, what factors should they consider when selecting and registering a trademark? And how early in the business journey should this happen?
It should be as early as possible. If today it's like right now, that is first thing, because it is the first filing phenomena. So whoever takes away the trademark would be in their name. Parallelly, we must understand that the first use concept or principle is also prevailing. That means if someone in some part of India is using the same trademark for a long time, that can also be a threat to you. So my advice to all the participants is, first check whether your selected trademark is being used by someone or not. Even similar trademarks are being used or not, which may put you in a difficulty. Like even Profol and Rofol are confusing trademark. So you will not get a trademark over Profol, since Rofol is already existing, and that too in a particular domain called pharma, where the life saving is very important. So no confusion is tolerated, right? So you must search first thoroughly in a particular domain in which you are working in, or your product you are trying to put in. So search is mandatory, and you should think three elements: same, similar, and substantially similar. So for example, if I'm picking up a trademark called AIMA for my management school, that is not really fair, because I'm trying to confuse the consumers in the market by taking the advantages of AIMA. So all those finer lines are being verified before the court whenever such confusion or such litigation take place.
Yeah, yeah, no, so I think similar sounding names also, like, you have this IIMs or IMAI, so people do get a little confused saying that, it sounds the same, and then, it might be the same college. I'm talking from my education perspective. So there was a very interesting, I remember speaking with you, Gopi, and you were talking about this D-shaped tablet, etc., from Troika Pharmaceuticals. I think it would be great if you could talk about that as well to the.
Oh, that's a very interesting case. Now, this Troika Pharmaceutical have been, considered as a trailblazer whenever any intellectual property rights are being concerned. So they are very, proactive in filing trademark, patents, design, whatever and whichever is possible, but all unique, even with the new thoughts. So one of their newer thoughts once upon a time was the Dynapar tablet having a D shape. Okay, so my participants might have used them. So it is a very peculiar D shape. The drug is very common. That is a painkiller, standard drug, diclofenac drug. So many companies are manufacturing it. But to stand out, even in that busy domain, what strategy they adopted was having a unique shape of the tablet. And there was not a rocket science, Dynapar, and then they had the D shape. Okay, and that was really a big news in the pharmaceutical industry. And eventually, whoever tried to copy that D shape, they filed an infringement suits, and they took those companies this tablets down, and they were enjoying monopoly for 15 years, because the life of any design rights are 10 years plus 5 years if you want to extend. So 15 years is the time period which you can, kind of enjoy in the design domain.
No, that's really eye-opening, hearing about all of these things. So there's this question which has come from the, I think, DOM management, I think the BN. He's written that there are many ideas that are sprouted by first-year students in the undergraduate course in the National Innovation and Startup Policy and the National Education Policy, which the sole aim is to make self-reliant at every very early young age. The main problem we found that there is a disconnect between society, industry, and university. How can we solve the disconnect and make youth innovative to make quantum jump in the economy by emphatically understand the problem with a secured solution? Is this a question around trademark, etc.? I must not.
I think it's a policy related,
Yeah.
so we can skip for now.
Oh, okay, so yeah, we'll pass that question. So Sanjay Sundaresan is asking, in your experience, how rigorous is the IPR enforcement in India now? In other words, if one goes through the process of securing IP rights, can they be defended legally from copycats?
Absolutely, yes. The courts are vigilant. The precedents are set. There are landmark judgments clearly stating out what is being copied, what is called infringement, what is called piracy, what is tolerable, what is not tolerable. So Indian law system is completely equipped with the understanding as well as with the precedents.
Okay, so they have something called C return on top of it, right? Which is copyrighted if there's something. So could you give us an example? Can you tell us, people talk a lot about content and from social media posts to, books that people write. And so how does that kind of work get protected by copyright?
Okay. So basically, intellectual property rights, no matter what, is designed to give the due credit to the one who developed it, one who thought for it. When it comes to C, that is copyright, the copyright creators are doing nothing else but they're expressing their thoughts through the music, paintings, sculptures, then novels, poems in their vernacular language or even English or any other language. Not only limiting to that, even movies, plays, then databases, then computer programs. These are all considered as textual expression. In one or other form, it is nothing else but some form of text. So all these are protected automatically under the Copyright Act once you write indigenously. If you have written by yourself, that becomes a natural or automatic
Not
copyright.
with ChatGPT.
Of course not. Of course not. That is a very new entry right now, right? But even before that, if you have kind of inspired or copied from someone, then it is not a unique one. So that is a copyright one. So when you write even a book, you have put in your efforts and even your emotions are attached to it. It's nothing else but your own baby. So you would not really allow or tolerate it being copied or infringed. Right? That's the emotion around this creation. So whoever copies, say book to book, you can really bring them before the court. If a substantial part is copied, even the characters are copied. The main characters are being copied with their names, with their chemistry, with the plots, then also can be brought before the court. Not only that, even when book is converted into plays or movies without the consent of the creator, that is also a breach of the law, the Copyright Act, and that can also be sorted out before the court. There are several examples from Bollywood industry for that.
Yeah, so but Gopi, there are lots of pictures whenever I see, and they always say that, this is any relation to something, this is a totally a piece of fiction, but any resemblance to anything closer. So if you write like that, are you protected?
No,
Before a movie starts or before a program starts?
see, that is a moral submission. But even after writing, you have copied, that's not fair. And what is not fair has to be protected.
Correct, correct. So, okay, so from, we're talking a lot about copyright, but there's a lot of question around patents which are out there and there are a lot of questions which are there in the group. So let's get into patent right now. So, Mahek, can we patent a process, basically a flow of information that makes a product in a competitive market stand out? Process. Can we patent that?
So what you've just mentioned is nothing else but a business idea, a business method. That cannot be patented. What can be patented is a chemical process.
Okay.
So,
and it needs to also be unique, right? And new?
It has to be
unique.
So all intellectual property rights have to be unique fundamentally.
No, but you can just put in a twist and say कि इतना सब तो ठीक है, it's become mine now.
No, Indian Patent Act is quite stringent. So little tweak is not entertained.
Okay.
There you need to prove substantial output.
Okay. So, I hope you got your answer, Mahek. So why Vinodini is asking, my grandmother used to prepare a refreshing drink for us, and I want to apply for patent. What is the procedure? If you could just give a broad understanding.
First of all, such recipes can't be patented.
It can't be patented?
It
Why?
can't be patented. Recipes are considered to be the admixture of different ingredients. So
It
recipes,
won't come under trade secret. I mean, it's like a refreshing
yeah,
drink. They
so
don't want to talk
that
about
can
it.
be protected in trade secrets, and that's what many such recipe holders are doing. If not others, then even ITC Dal Bukhara
Correct. Dal
been
bukhara.
holding that secret.
Couple of these Mughlai dishes, 200, 300-year-old dishes, which are
Mhm.
there. So they put it under trade secret.
Yes.
So if Vinodini wants to put this recipe of this refreshing drink under trade secret, he can do it.
Yes, if she's not filing anything, she's keeping secret by herself. And she's disclosing the drink, the ingredients to the authorities wherever it is required. That's it. But the right preparation is not supposed to be disclosed. The methodology.
Okay. Okay. So there was this big, I come from Orissa. So we had this entire fight with West Bengal around Rasgulla. So what is that? Is it around patent,
It was around
copyright, trade secret?
geographical
What was it?
indication.
Trade secret?
It was around
Oh.
geographical indication. That which is the origin of Rasgulla? Is it West Bengal or Orissa?
Oh, good. Okay, so okay, let me now get, and there are a lot of questions here, also around trademark infringement. What are the process to inform a person?
Yeah, ma'am, Rashmi is trying to reconnect.
I got lost. Can you hear me now?
Yes.
I'm so sorry. I'm so sorry. Some problem with the internet. I'm really sorry for that. Okay, so we were talking about, there's a lot of questions here on the chat as well. They're saying that it is said that the Indian Patent Office is now granting patents within a year. If the request for publication expedited examination is filed along with the complete specifications and application, what is the earliest that one can expect the patent to be granted?
So I think the question has its answer. It is less than a year. So they have really, the patent office have geared up really well. And whenever the expedited examination is filed, number one, we get the examination report quite early compared to other routine applications. And if the given invention, the given patent application is indeed unique over the prior arts, then the processing time is significantly reduced, and that's how you're getting a grant in less than a year or around a year. But imagining you are competing with many existing patent application or other prior arts, you have to really comply back and forth through examination reports, through hearings, which will take its time.
Okay. So there's also an interesting question, especially for startups. Vinayak Shastri is asking, how long does it take to patent a product or idea? Is an MVP or a working prototype model, which people usually use right now to get funding, etc. can also is supposed to be patented, and what are the typical costs associated with it?
So here the thing comes, let's say I have again, tried to patent this particular concept. When I scroll this down or up, it has certain movement. Now this is quite breakthrough. Imagining this to be filed as a patent application, I must file the patent application first of all as early as possible. Number one. Number two, I must get the MVP done. Then only the fine tuning of this product will come up. Its operation would be streamlined, and that same shall be expressed. So it automatically will not look hypothetical, and you will be able to provide the test data also, which is very important part, which many a times are missed by the applicant, but it is one of the most important part which proves automatically that look, it is working. It is just not a thought. It's not an idea only. It is a working product, right? And then only you should go to the market for funding, for its exploration, for its advertisement, in whichever way you want to discuss. But first and foremost is filing the patent application, the primary one, which is known as provisional application. Second is MVP. Third is complete specification. Fourth is discussion with the market. So not to miss this. If the sequence is changed, your patent rights are lost and lost forever.
So if I go to the market and I get some changes done, because I've already filed the patent, I have to file it again?
That's strategic. If there are minor changes, they can be filed through amendments. But if there are substantial changes which changes the output, then that can be patent of addition or a separate patent application. So I think this is very technical. It has to be discussed case to case basis.
Good. So there's an interesting question from Sundar, where you're saying we're using a third-party product, but I'm making my own creative content. For example, when a freelancer or a consultant creates a PowerPoint presentation using smart art, licensed stock images, are such presentations automatically protected by copyright?
They're
Because I've used my
automatically,
own
they're
mind.
automatic. Can you repeat the question, or can you tell me in which? Because this is a long
When
question.
a freelancer or a consultant creates a PowerPoint presentation using
Okay.
smart art, licensed stock images,
Using?
any of the stock images which are licensed, it could
Okay.
be, the photographs which are there, are such presentations automatically protected by copyright? It's
They
used
are
in third
see,
party.
see, here there are two things. They are automatically protected, yes. But the images you have sourced,
Getty
have
images or
sourced
something like
ethically. Let's say ethically, they were free downloads images. You ethically source them. So your particular copyright work is in your name, excluding those images.
that.
So for example, I'm filing a copyright application for this presentation. Then I have to mention that, look, this is my original work, and these are the images I've sourced from these sources.
Nice. Arun Pandit is asking, can we patent an algorithm?
No, we cannot in India.
Why not in India? Why abroad?
Abroad, there is just one country named the United States of America allow algorithm in a certain way, not entirely. In India, our philosophy is that the product should be in working capacity. An algorithm is a guideline. It's not a working product. That's why.
Okay. ACU VC Conclave is asking, can we patent a business idea?
No, not.
Idea.
No, not. I think we have discussed.
Yeah. Okay, so there was this entire conversation on Chat GPT that we are asking. So Tarun Kohli is asking if we use some images from Chat GPT or other AI tools for making a content, is it going to lead to some copyright issues?
It is bringing copyright
I think
issues
ethical
right now. The guidelines or the amendment in laws are being discussed widely, even nationally and internationally. So very soon we'll have clear guidelines, but ethically, they are being sourced without the consent of that owner. So they are not really ethical.
So, for example, if I click a picture of a celebrity, I mean, and with the celebrities' knowledge, saying that, I've clicked your photo, but I have clicked it, it's on my phone. And I end up using it and I, sort of get money out of it. I don't know, whatever I end up doing. Can the celebrity sue me?
If it is with her permission or his
Because I
permission.
might have made money out of it. For whatever reason, I would have sold it to some magazine or
If it
something.
is,
Or
see, the broader practice is, yes, it is ethical because you took it with the person's permission.
permission. Yeah.
You clicked it, number two, right? And it was
Yeah.
not obscene or, it was not uncomfortable.
Yeah.
Then it's absolutely fine.
Okay. Good. So there is this question from Dr. Lab Singh. He says, can a cricket bowler or a batsman protect his style of playing under an IPR Act? I know there are a couple of these cricketers who have a typical way of bowling and typical way of, batting. Can
So
that be protected?
no, they cannot be protected because those are human actions. And human actions cannot be protected because you cannot restrict someone to act in a certain way. But if a cricket cap is designed in a very different way by a cricketer, for example, then that product can be, protected under the right category.
Okay, interesting. So any other one example that you can give around this?
For example, Sachin Tendulkar has his name registered under Trademark Act. And you know
Okay.
what? He has several restaurants.
Restaurants, yeah.
Right? To start with. Then under that name, you keep increasing your product range and you can encash your name. So now Sachin Tendulkar, for example, is a name, a celebrity, or some goodwill is attached. When you say it's a Sachin Tendulkar restaurant, you feel that it will be authentic. It will be genuine. It will be, unique. So you would tend to go there and explore. So that goodwill Sachin Tendulkar has created over the years, and that he is encashing through different product lines. So SRK, Shah Rukh Khan has the perfumes. I think Shilpa Shetty is also perfume lineup, and so on and so forth. I mean, several examples. So they are converting their brand name into the other product lineup. And that's the beauty of intellectual property, right? Even the co-branding is possible.
Yeah, Rishika Arora is talking about the same action that you. She's saying, for example, if someone replicates MS Dhoni's helicopter shot in an advertisement, can the makers be sued?
If they, Rashmi. So if they try to project that particular character as a MS Dhoni by the getup, by the body language, then they can be sued because it is a passing off. But that helicopter shot can't be refrained.
Rhythm, okay, if my internet is going off, I'm going to, connecting through my phone, but my phone, I'm not able to unmute here myself.
Yeah, you may switch off your
So
video,
you could
Rashmi.
just help me with that.
You
Yeah,
may
no,
switch
I
off
don't
your
know. I
video or
think there's
something.
some.
Okay. Okay.
I'm really sorry, audience. For this. Rhythm, if you can just unmute Dr. Lab Singh, please.
Yeah. Yes, Rashmi, we are doing it.
Dr. Lab, you have raised your hand. Do you want to speak? Okay, I don't know. I think he just raised it like that. Okay, so let's keep going on to the questions. A lot of questions which are there. So okay, so last question from Vinayak Shastri is, how much should one budget for filing a patent or a product in India? Can we file patents for the same product as a global patent or in multiple countries?
So I will answer the second question first, which says, can we file patents for the same product as a global patent or in multiple countries? The answer is yes, you can file the same product, the same patent, referring the same patent application into multiple countries by filing a single gateway international application called PCT application. But one has to keep in mind always that there is nothing called global patent. Because in every country, the acts are different, the guidelines are different. So there is a gateway from United Nations called WIPO, and then comes PCT application, which helps you to enter into multiple countries. Right now, 156 countries are members of this PCT application. And eventually you can enter into the country of your interest. And coming to the first question, the budget.
Yeah.
Budget is very subjective. I think this is not a forum to talk because it depends on which, are you a startup or an individual, which entity you are, and where you are entering. Is it a complete specification? It is a provisional application. So all different criterias come together and finalize the budget. But you can drop this question and we can answer you separately through email.
Okay. So, so there is this thing about, and I think we should be taking that example of the author. There's a question from Ashwini Gupta. Says, can you guide me about drafting contracts to buy copyright and new manuscripts from new authors and later getting them published for profit? So he's talking about contract drafting of something that has been written. So would you want to give the Harry Potter J.K. Rowling example as well and also answer this question?
I know. So whoever owns the copyright has their monopolistic right for the lifetime of that creator plus 60 years.
Wow.
Right. So, and that particular copyright can be converted into any book, in a formal book. It can also be converted into audiobooks, then plays, or even movies. Not only that, it can also be converted into merchandises, even the amusement park setups. Right? So at every junction, the contract would be different. Or there could be one big contract covering all of this. So I think both the parties have to sit together and come to a common consensus, and then only such contracts may be drafted. So there can be a single answer on it.
Okay, so so there's a connected question here. I'm a researcher. Up to how many words can I reproduce verbatim of some other writer in my work?
See, it is not really counted by number or number of words. It is by the impact it is counted. I would ask this audience one question, that if I, kind of sing Apnito, so most of my participants would answer that Jaise Taise. Right? So this is a very popular song which starts with Apnito, and then, the listeners automatically or somehow they feel that this can only be the answer. So they were just two word apnito, but still it has its impact. So it is never about the number of words, it's about the impact it is making.
Okay. Um, um, so, when we think of, can you hear me, Gopi?
The voice is not really clear, but we can still give it a try.
Yeah, hi. So, okay. So sorry. I don't know why the internet connection in the office is like really, it's just not working out. I'm really sorry for the problem here. Gopi, we were going in a great conversation. So I just wanted to, so there were a couple of queries also which are here. Um, so there is this last question from Arvind Kumar. He says, you talked about PCT. What are the key differences between filing patents via PCT or via national filings, and when should each be used?
Okay, so the word national filing is something I would like to, bifurcate. There are two ways of looking at it. Number one, it is through conventional filing or one-to-one country filing. So if I'm filing from India to a country named Australia, from straight away from one country to other, it is considered as a conventional filing, wherein I'm not taking help of any treaty. That is also possible because the countries overall have also separately agreed on such patent treaties. At the same time, the most popular and most useful is PCT, that is Patent Cooperation Treaty, which you start from India, go for PCT filing, and then in a given time period, you choose the countries of your interest, which gives you a better leverage of time, even the budgeting and your business decision.
Okay. No, that's good. So there's this very interesting question from Harpal Singh, where it says, when we think of handicraft market, what are the key ideas to consider for protecting your ideas and plan for trademark? Handicraft will come under GI?
Handicraft do come under GI, so that is where you claim that I am from this region. For example, I'm selling rasgulla, and I'm saying that it's a geographical indication tag under West Bengal, and your particular product must be manufactured within the West Bengal, number one, because the place of origin has to be continued, because that only adds the flavor, the water, the composition, the atmosphere, that is what makes the final product. And Last but not the least, it's a recipe. So altogether, it makes a particular rasgulla which you can claim as West Bengal rasgulla. And fundamentally, you have to be a member of that particular cooperative society. So that is a part of GI. But when I'm selling, I have to sell under some brand name. So that brand name selection can be anything. It is up to your choice. There is no restriction here. But at least not West Bengal, Rasgulla as your brand name, because that's very generic. And for trademark, it is always advisable to avoid the generic name, the national names, the places of worship, etc., because they're considerable to, not only to one person, to everyone.
Okay. So, so there are a lot of questions. We are just 3 minutes before the close of the session. Let me just take these questions faster.
Okay.
There is this one question about, there are a lot of questions about how do I check whether this is a patent, whether I can patent for this. Like there's a question around, I designed a cutting tool with some geometrical modifications from existing studies. Now I want to explore whether this design is patentable. How can I check for the same? And there was a similar question on the top as well. So how do I check whether this is already not got patented?
So there are two elements here. First of all, there is something called design and there is something called patentable. So kindly bifurcate them. Design would go for the outer appearance only. For example, I'm selecting this particular, I'm buying this particular spectacles because of its design. I'm buying this particular glass because of its design. It's outer appearance only. Right? So when you make a particular geometrical modification, and the end product provide a better performance, it will straight away go to the patentable domain. If it is a modification for just its exterior purposes, the outer looks only, then it will go under design. Both can be searched through internet.
Okay. So, Gopi, I think there is a lot of interest, I think, with the kind of questions, and the questions are pouring in right now, but I know we've just a minute left and we close our sessions on time. So is there a way to get in touch with you? If you can just share your email address, we can put.
I'm sharing in the chat box. Rhythm?
Yeah.
Is that okay?
Rhythm, is it okay if she puts her email address on the?
Yes, sure. Yes, sure.
So, before we close, Gopi, if you can please write it down. But one last piece of advice around IPR filing. What was your advice to layman in India about IPR rights?
Okay. I would say consider these as an asset, not as a cost. You're building a portfolio. It may look very small right now. It may look very unimportant right now, but you never know how and in which scale it will shape up in future. And try building things around that particular IPR. Maybe your brand name, maybe your design, make it your identity and build your goodwill, which will reflect in your valuation in a longer run. And that's how this all enterprises whose example we would like to quote have shaped their journey. So all the participants, we would like to use your example in the next session. Make one out of this.
Okay, so thank you so much, Gopi. I think a big eye opener, and it sort of helps us also, sort of gave a lot of perspective about what we are looking for, business idea, anything that we've made, trade secret, trademark, patent, copyright, GI, semiconductors, etc., etc. So there is, and I'm sure it'll keep changing. So thank you.
I must thank the participants. They were really engaging. They were really inquisitive to know things around. So thank you so much for your, kind of interest throughout the session.
Yeah, absolutely. I think, and they were at some point of time, there was about almost closer to 200 people there. So I think now they're all leaving. So thank you so much, Gopi.
Thank you.
It was a big success. Rhythm, you should call her again. And I think there's a lot of questions around it. Maybe we should be taking subsection, only one call around.
That makes more sense. Yes, yes.
I should be doing that. Thank you so much for taking out your time.
Thank you so much. Thank you, Ridham, and thank you, Rashmi, for wonderful moderation. Thank you, AIMA.
Thank you.
Thank you everyone for joining the session today. Thank you.